matter of Michelle Biden and Waverley Borough Council.
Right. Mr. Straker, before we begin, can we do some housekeeping,
of course,
please? First of all, there is a request, within the skeleton arguments at least, that the address of, the address that was offered to Miss Biden should not be revealed in the judgment. Is that still a request made?
can I respond to that in the course of the day? Because I haven't had an opportunity this morning to take exact instructions upon that question.
All right.
And I wouldn't want to answer the question without having done so.
Understand. The second is this. By which title does Miss Biden go to? Miss, Ms or MX?
Mrs.
Mrs. Thank you very much. And that should appear in the judgment also, Mrs.
Much obliged.
Thank you. Now, I can help you to this extent, Mr. Straker, and also Mr. Rutledge. We've obviously had the opportunity to read the papers. We have had regard to the authorities, which we anticipate you will take us to. We do not need to have the context of housing duties explained to us. This case is about suitability, and suitability in the context of the protected characteristics of disability and gender reassignment. So please don't feel the necessity to go back to the letter A in the alphabet, Mr. Straker. I'd much rather, and I know that my lady and my lord also would much rather focus on the points here.
My lady, that will be the case, therefore. Just in response, if I may, touching upon this case is about suitability, we would say this case is about the inquiries necessary in order for consideration of that question. My lady, as the court knows, I appear with Annabel Heath for the appellant, my learned friends Mr. Rutledge and Mr. Peck for the respondent, local authority. And as has been indicated, and as I would wish to proceed, I take the papers, so to speak, as read, and the principal proposition that we want to advance to this court is that the inquiries made were legally inadequate so as to deprive the reviewing officer, in effect, of the entitlement to reach the decision. And the proposition that we advance from the authorities is that the inquiries must be sufficient fairly to inform, in this case the reviewing officer, about the topic of this case, suitability. And I add to that proposition, if I may, this gloss, that question of fairness, fairly to inform, is to be determined not by reference to that which an individual applicant may, so to speak, present to the housing authority, but rather by way of a proper response in the light, for example, of any protected characteristics by the authority to the individual. And the court will undoubtedly have noticed that in giving permission, the references is at page 147 of the core bundle, Lord Justice Arnold indicated that matters of principle touching upon inquiries may well appear in this case, and we say that is so. Having in mind the observation as far as the housing legislation is concerned, the base decision here is referable to section 189, capital letter B, which is, though I don't take the court through it in the light of the observation made, at page 32 and 33 of the bundle of authorities. The serious consequence of the decision that was made is given by section 193, capital letter A. And effectively enables the authority to say, we've performed our duty, you've refused the accommodation, notwithstanding the homeless status. 202 and 204 provide respectively for the right to request review and the appeal. The court will also have seen the letter at 144 of the core bundle, and if I can just identify that for the court, that is the decision letter which led to the review and you will see that it set out correctly in accordance with the requirements that there was a right to request a review in respect of that, which was done, page 144 being dated the 10th of January 20, and then that we get to the review itself, which is the critical document as far as this court is concerned, which is 18th of August 2020 at page 124 and following. Now, we would readily acknowledge that although this is the critical document for our purposes, that it constitutes a highly competent explanation of what occurred and plainly reveals that the author was alive to matters which arise under this legislation, which legislation is not without its difficulties. But I readily make that acknowledgement. And it's perfectly clear that the reviewing officer, as I shall call Elizabeth Donaldson, who made this decision, took into account a number of matters which were critical to be taken into account, to include the access to proper medical care, see page 133 towards the foot of the page, essential that you're registered with a GP's practice. It doesn't follow that you need to be registered with one in Wokingham, although that was the position. Also taken into account quite clearly was see page 139 and following, the question of safety, which is dealt with over a number of lettered paragraphs. Also taken into account was the protected characteristic which the appellant has. So all those matters were there, and if one was simply proceeding upon a basis of an exercise in saying, were certain matters considered, and can you point to matters not being considered, I would have no case in front of this court. I must acknowledge that. But the whole exercise has to go further than that, because the identification of these matters, together with a recognition by the reviewing officer that there was in fact an obligation to make inquiries, and I don't need at this stage to turn it up, but you may have noticed in the supplementary bundle there's a witness statement by the reviewing officer which talks about her entitlement to and ability to make inquiries. Means that those inquiries which we say were fairly necessary to be made in order to secure a proper decision about this question of suitability of the accommodation, it's those matters which we say were missing. And it's here that I can take, and I apologise if I'm taking this too quickly and moving straight into the meat of the case, but I can take the court to the first case which touched upon how one should really decide upon this level of inquiry to be taken, which is the Bayani case. And the Bayani case occurred at a stage when, under the legislation, there was no provision for the review exercise which we now have, or for the appeals to the Court of Appeal. It was judicial review or nothing. And the court will find it behind flag 11. And it was a decision of the Court of Appeal, presided over by Lord Justice Neal. It has to be said it was a majority decision of the Court of Appeal, and it related to someone who was living in the Philippines, and the question arose as to whether she was intentionally homeless from that place in the Philippines. And the court will see at page 104 that in the headnote it's recorded that the duty was to make inquiries, because one had to make inquiries as to whether or not the lady was intentionally homeless, is to make such inquiries as are necessary to satisfy the authority. As it is the authority which have to be satisfied, the scope and scale of the inquiries is primarily at least a matter for them. And just pausing there, in the base legislative material in connection with this matter in section 189B, one will see the relevant word satisfied, referable to the question of suitability. And then if one goes on in the text, if I may, page 106 of the authorities bundle, 409 of the report, the learned Lord Justice drew attention to some general considerations which he took as the established position, and there one sees the duty to make inquiries is to make such inquiries as are necessary to satisfy the authority. as it is the authority which have to be satisfied, the scope and scale is primarily, at least, a matter for them. But the introduction of the word necessary indicates there's a standard which these inquiries must observe. Now, I don't need to read on the balance of those matters which were there set out, but the court may care to notice that at page 112, and I think this has been sidelined at the foot of the page, that the judge recorded, as I say, at the foot of the page, in my judgment, it would have been much more satisfactory had Mr. Trendle, he was the Kensington and Chelsea's officer, asked her further question to enable him to appreciate fully the importance of the earnings of Mrs. Bayani. And it was a pity he didn't question her about her prospects of employment in Manila. But then, nonetheless, he goes on to reach the conclusion that was apparent that he wasn't going to intervene with the council's decision because merely it was thought by him that further inquiries would have been sensible or desirable because it was for the council. Lord Justice Nichols was to similar effect, and it was Lady Justice Butler Sloss who dissented. But Lord Justice Nichols, I draw attention to, if I may, because it's from him that I have taken the language of the proposition that I advanced to the court in opening my submissions this morning. Because Lord Justice Nichols was as clear may be in terms of the situation was one whereby the council's decision was properly made. But if one looks at the foot of the page of 114, he describes what the housing officer would know, some of which was notorious, as we all do, about modest sums of sterling here and some other countries being rather more advantageous than they are here. And then he goes on to say this: I consider that, given that knowledge, and given what he knew about the accommodation in Manila, the housing officer knew enough to form a view fairly on the question he had to answer. So, as I say, it was that language which prompted me in making this proposition and advancing the proposition that I do, and highlighting that adverb fairly, because, as we will come to see, in the light of the development of the law and in the light of the protection of protected characteristics and the level of care which needs to be given in given circumstances, touching upon a disability or otherwise, that question of fairness is a matter of considerable importance. So I leave Bayani there, if I may, and take that sequence further forward because we know that if one looks now at the supplementary bundle, that in connection with a number of matters, aspects arise which might not be as readily apparent, if I can put it this way, to you or to me, as one would have hoped, and upon which it is necessary, in the light of what has occurred and in the light of the advice which is given, to take account. So that if you go in the supplementary bundle to page 131, you will find yourselves in a document which is labelled official and is in fact a document from the College of Policing, the professional body for policing. It was exhibited to the judge below in a witness statement by my client. It's dated, in fact, 2014. And at 131, you will see at the top of the page that it says many police forces have introduced lesbian, gay, bisexual, transgender liaison officers with specific responsibility for building community links and providing support to victims and witnesses of transgender hate crime. For this role to be successful, forces must recognise the need for ongoing investment in training and support. It's also essential that liaison officers are allocated the time to perform the role so that they can meet the needs of the community effectively. This liaison role helps build trust and confidence, increases accessibility to the police through an identified contact point, and provides a specialist advice point for other officers. And so what one has here is it being stated in 2014. This is the way a police force should be proceeding because of the special circumstances that attach to certain people, and therefore there should be such a person, and that person will provide a specialist advice point for other officers. And if I may, whilst one has this document to hand, go to page 20 and 21 within it, where one has left the police document and is in a document which is a report by Stonewall.
Sorry, pages.
The report begins at page 17 of the supplementary bundle, my lord, and the pages I'm going to refer to are at page 20 and 21.
That's 20 and 21 of the bundle.
That's right, yes.
Thank you. I'm sorry, I was looking for 20 within the document
yes,
we were
it says P20
Thank you.
on it. And one always has another number simply to confuse rather than to elucidate, but P20 is what I was looking for to draw the court's attention. And there one sees that the first bullet point, top left, beneath key findings, 2 in 5 trans people, slightly more in fact, 41%, and 3 in 10 non-binary people have experienced a hate crime or incident because of their gender identity in the last 12 months. And then certain other details and statistics are given, touching upon difficulties which are experienced, which arise in the context of living lives with others who may not be so immediately appreciative of certain matters touching upon, for example, transgender people. And on page 21, one has under the heading Facing Discrimination and Abuse, this research reveals the inequalities faced by trans people in Britain today. By the way, the report is dated 2018. The research reveals the inequalities faced by those people today. It shows the extent of subjected to hate crime and how many report it to the police. It also reveals the day-to-day discrimination they experience at work, in education, or when accessing. And then in rather small type, I'm afraid, it goes on to say about the level of reporting, because it's headed it, how many people reported. Hate crime against trans people is significantly, left-hand side, just by the second hole punch, is significantly under-reported. 4 in 5 don't report it to the police. Some trans people who report a hate crime don't feel supported by the police or experience even further discrimination. So one has a circumstance which confronts us all and confronts the police of underreporting in a circumstance as reported, where in certain instances, unfortunately, those who report such matters don't in fact feel supported by the police.
Can I just ask Mr. Straker where this fits into this case? If the report accurately represents the statistics, a large number of people in Mrs. Biden's circumstances, and she herself in her statement says the same, she has not reported incidents because she thinks that they will be swept under the carpet or whatever. So, having that information, how would that have assisted Miss Donoghue?
Where it will have assisted her is not so much necessarily in having that specific information as to whether it's 79% or 81% reporting, but to have alerted her to this being a matter which, to enable inquiries to be fair, I must, putting myself in her shoes, I must inquire further about these safety aspects, or indeed any other aspects touching upon the protected characteristics, because if one goes back
About the safety aspects of what?
Oh, the safety aspects of simply living in that proffered accommodation.
And how would she do that? Because if there's no backdrop of transgender hate crimes, she's going to come up with a circumstance where she said, well, I've made the inquiries, I appreciate that there's under-reporting, but I can't go to each and every person in the borough and say, do you have a protected characteristic by way of reassignment of gender? Have you suffered transphobic abuse or assault that you have not reported, so that I can put that into the equation? I mean, where does it take us, Mr. Straker?
It takes us here. If one goes back to the review officer's report letter,
Yes.
at page 140 of the core bundle,
Yep.
the first paragraph on 140 has the letter F against it. I have contacted the police and made inquiries with John Francis, and just so to cross-reference it at the end of the supplementary bundle, you'll see there's a note, or may have seen there's a note recording a telephone conversation which took place. With John Francis, the police community support officer, local to the Waden Lane and Southern Way area, he gave me the following information. Farnham is a low crime area, etc. I don't read on, and then it says threats of violence are almost non-existent. There's no evidence of LGBT plus hate crime in the area, and then a mixture of vulnerable people and ordinary people living in the area. PCSO Francis described residents as law-abiding citizens and that he wasn't aware of any individual harbouring any grudges towards any member of the LGBT plus community. Now, if one pauses there for a moment, she plainly thought it necessary to make an inquiry.
Mm.
The inquiry was made of a community support officer. The inquiry was not made of an officer, nor was she directed to an officer of the kind described in the College of Policing report.
And what would that have done? Because if one assumes that Miss Donaldson must look not in general, but at the circumstances of this case, that is, this area, suppose she'd gone to the liaison officer, far distant, and he had said to her, well, you should know that these reports that are made are atypical because, generally speaking, there is underreporting. We are trying now to encourage reports, but they're not coming through. So where would that have taken her?
Well, it would
How should she have put it into the balance?
Well, it would have taken her to a position where she would have been inevitably better informed in connection with.
In what way, Mr. Straker? I mean, we're going around the houses here, and I want you to focus in
Yes,
because this is the point of the appeal.
Yes.
How would it have made a difference to her to have regard to that part of the Stonewall report that you've taken us to, and the fact that there's a liaison officer, where the liaison officer wasn't local to this address? How would it have taken her any further forwards?
Well, because the liaison officer, the liaison police officer, would have had at his or her fingertips the material relating to the kind of treatment which is recorded as having been underreported, the kind of treatment which is viewed as objectionable, but which passes by to a considerable extent if one's not focusing upon it.
So can you give me some examples, please? We have in this case Miss Biden giving examples of being targeted by a particular person, and also she said in her statement that was before the court, I've also taken protective orders against others,
Yes.
although she doesn't name them, she doesn't give any other details. So if Miss Donaldson, who in her report says, I can understand that you have these fears, and I accept that you are genuinely believing that there is this surrounding atmosphere that puts you in danger of this type of offence, what would it be that going to the LGBT liaison officer and finding out that these are the kind of things that may happen that are underreported, when she had first-hand information from Miss Biden telling her that this is what I've suffered from?
Yes. It would help in this way, in my respectful submission, that she would have a fuller and better picture of the situation that obtained in respect of the LGBT community and in respect of the likelihood of hate crimes in respect of them. And the position then that obtains is that she, the reviewing officer, in considering the information which she has been given by the Mrs. Biden, knows I must proceed here very cautiously because it is likely to be the case that any view that is suggested in relation to the general levels of anti-LGBT people activities is going to be understated, and therefore I must view and judge in a somewhat different way the position that was advanced that I would otherwise have done if I hadn't made those inquiries.
So tell me, in the perfect world, what would she have done then? If she'd taken those matters into account, as you say that she should, where would she have arrived?
Well,
in this case?
Yes. Well, I say that she would have, or may have, arrived at a view that the proffered accommodation was not suitable.
Why?
Because of the level of difficulties that was likely to be experienced by Mrs. Biden in living there, either because of the position which is unfortunately a position which is taken, if I may use the expression, by many, many others, of one of objection to or hatred of those with such a protected characteristic. and would take the view, well, in those circumstances, the position is one whereby Mrs. Biden has been saying, consistently saying, the position is one whereby I would be better placed elsewhere than here, nearer my support network and so forth. And therefore, this can be viewed in that way.
So can we look at that proposition now? If what you've said appertains, that could arise in every single offer of accommodation, that because there's underreporting of LGBT, transphobic abuse, assaults, all of the rest that goes with it, that every officer has got to have regard to the fact that there may be living next door somebody who may make the life of the applicant before them hell. Now, on that basis, I think you've gone on to say, well, in this case, Mrs. Biden's point that she needed a support network would hold sway. But what difference would the support network make to the fact of underreported transphobic crime?
Well, it wouldn't change the numbers, obviously, as far as that is concerned, but it puts her in a better position because of proximity to that support network. But
isn't the difficulty with that the support network's in Wokingham, and this is Waverley Borough Council?
Yes.
Furthermore, as a general proposition, and with great respect to Wokingham, Farnham is, as described here, a low crime area. The same might not be true of Wokingham.
Well, no doubt there are different, so to speak, pockets within it.
Wokingham, Winnersh, and that part is possibly not as, in inverted commas, nice, close inverted commas, as Farnham.
Yeah, well, undoubtedly, each place varies place to place and within it.
But where does this go, given that this was the best that Waverley could do in terms of a place within their patch, close to Wokingham?
Well, one has to take a step back, if I may, in connection with this, because it's asked what would have been the outcome, and it can be remembered here that the character of the case is these inquiries were insufficient for the purpose of the exercise, and so one's not saying that the outcome would be bound to be A or B, because by definition those inquiries which one's asking for or suggesting have not been made, and so one doesn't know what the reviewing officer would have done, what the council...
No, my lady's question was simply, what possible difference could it have made?
Well, similarly...
In this case, on these facts.
Yes.
And that's the, speaking for myself, that's the issue in the appeal. What possible difference could it have made?
Well,
it's not necessarily saying there's got to be a specific different outcome, just, well, so what?
Well, I think there would be two answers to that, I would suggest. The first answer would be that in any event, an applicant in this circumstance should know at the end of it that she had been dealt with in a way which falls within the description fair inquiries have been made. That's point number one. And point number two is on this question of might there have been somewhere else within Waverley which would be better in these terms, that is to say the security terms and so forth. That's not a matter where there's any definite evidence one way or another before the court, I would say.
Well, there is. You've invited us to the evidence of opinion from Stonewall saying that wherever you go, whoever you ask, a liaison officer will understand that there's underreporting, but the fact of underreporting means that you're always going to get the same answer. Whatever the reports have been, there's been underreporting.
Yes, but that doesn't, quite with respect, deal with the point as to whether or no within any geographic area, there might be somewhere which is proportionately better from the point of view of comfort, security, and apprehension as to...
Well, tell us, Mr. Straker, that's what I'm pushing, and I'm
Well, I
doing it
can't
very
give you-
clumsily.
yeah.
So tell us what that would be in this case. We're dealing with Waverley, a small borough. They are attempting, in accordance with the guidance and the regulations, to find somewhere that is not too far distant from the address at which Mrs. Biden is going to be evicted. And they come up with accommodation 0.9 miles away. Now, they are entitled to take into account that that's somewhere that Mrs. Biden has been living, that presumably she'd continue to live. She certainly wouldn't have been able to come to the council and say, I'm homeless, if she hadn't been evicted. So they look for somewhere that's 0.9 miles away. And they come to the conclusion that given that it's 0.9 miles away, it's not unreasonable to consider that the same circumstances appertain. And PCSO Francis pretty much confirms that.
Yes. And as I say, what that...
You're asking for preferential treatment, aren't you? Isn't this the point that you're making in your appeal?
I would say no, that I'm not asking for preferential treatment, but rather I'm asking for treatment which takes sufficiently into account the position, the individual position in which I find myself with the characteristics which I have and the infirmity which I have. So that's what I'm asking, not for preference in connection with that. And also I'm not asking for a circumstance whereby if fair inquiries going to the liaison police officer produced different information, produced a higher level of intelligence as far as what the circumstances were bearing upon hate crime, for example, than would otherwise have been taken into account. I'm not saying that it must therefore be the case that Mrs. Biden, so to speak, elbows out someone else.
Right. Thank you.
Because I
So
don't think
can I
could
just
properly
ask you
say
to take through one of the points that you made in that sentence, which is fair inquiries may well have revealed a level of information to assist in taking into account circumstances that may not otherwise be appreciated.
Yes.
Now, what are those circumstances? What would be the higher level of intelligence that you're referring to?
Well, it would be the kind of information that the liaison officer from the police force would be able to give with the knowledge which had been acquired over a period of time of first the general position, by which I mean the general position which affects all of us in our level of appreciation, which is an underappreciation of the problems encountered by people in the position of my client. And that's point number one, general. Point number two is specific, that the liaison officer, police liaison officer, would be able to be more specific about the circumstances bearing upon the area in question from his or her knowledge of what the situation there was in the role as liaison officer, and would be able to, as the College of Policing operate, as says, provide a source of specialist advice in connection with these matters.
So are you saying in relation to the liaison officer, first of all, they would have informed the reviewing officer of the nature of the beast, that there is
Yes.
such an amount of underreporting?
Yes.
And secondly, they would have informed the reviewing officer of the actual state on the ground near the proposed premises.
Yes.
So are you saying that they would have better knowledge of that than Officer Francis?
Necessarily, because the police community support officer, I'm sure, is doing his job perfectly well, but his job is not the specialist job of the liaison officer, and does not have the focus that the liaison officer has, so that he gives what may be described as generalized information: low crime area, what crimes occur, typically shed and garage break-ins. But that is the general population, if you like, that he is there describing. What he's not or not able to get to grips with is the kind of information that a liaison officer would have in the way described in the College of Policing document, the knowledge how this touched upon and dealt with people such as my client. That's what
So you're sorry, Mr. Strang, I didn't mean to interrupt. So you're actually saying, putting aside the underreporting issue, the general attitude, put it that way, to this kind of crime, you're saying actually that the liaison officer would have statistics about actual hate crimes in relation to transgender people in the particular area that was not available to the PCSO.
I don't want to say something which I can't legitimately say to the court, because I can't legitimately say to the court that he would have had these particular numbers and so forth, because I haven't got that information. But he would have been in a position to be able to provide, if I can use an old-fashioned expression, further and better particulars. And that is no doubt part of his role in order to do so. And it's that step which was omitted from being done, no doubt because, and once again, one gets into a circumstance of this could be potentially a criticism of, I hope I can forgive him for saying this, of us all, and we don't necessarily consider all these circumstances which bear in such cases, and so that you need somebody who on a day-to-day basis deals with it from a particular point of view, the liaison officer as described by the College of Policing. That's how it goes.
So that the PCSO didn't have sufficient focus, you would say, on the relevant issues, and therefore it's possible that he didn't have information about this kind of actual hate crime, not underreporting or anything else, actual statistics. And it's possible that the liaison officer would, in relation to this particular area.
Yes.
That's what you're saying.
That's how it goes. And when one's dealing with an inquiries case, there's always a difficulty in the sense of one's saying insufficiency of inquiries, and then, well, what would the inquiries have revealed? And
No, we've been asking you what the inquiries would be, not they would have revealed.
Oh, I beg your pardon.
What the inquiries would be, and that was the point of my lady's question. What would the inquiries actually be that Miss Donaldson should have made?
Well, the inquiries that...
I think you've been there already,
Okay, thanks,
Mr.
thank you.
Straker. Yes, I'm keeping an eye on the
So
time
sorry.
because you're on the first ground at the moment.
Yes, and I can readily acknowledge, as my learned friend Skeleton mentions, that the grounds rather run into one another.
They do.
So anyway, that debate, if I can draw a line, so to speak, there in connection with that, because what I would next wish to show the court is how matters have progressed in terms of how one deals and fairly deals with the sort of circumstance which confronts Mrs. Biden. And for that purpose, can I ask you to go to the bundle of authorities at page 163 within the bundle of authorities. You have the Court of Appeal decision in Cadona, with the judgment being given by Lord Justice Old in 2005, and sidelined authorities on the meaning of suitability, a number of basic propositions. I'm not going to read out the full extent of this text. The position is one whereby the character of the text which Lord Justice Old goes through reveals that one is, if I can use this word, personalising the matter because suitability stands to be judged in individual cases. So one sees at the bottom that so also, paragraph 35, in individual cases must the nature of the property and so forth. Location could be of great relevance to the suitability of accommodation offered to a particular applicant. And then the example of ready accessibility to public transport or shops or schools or a local property, or whether it's in an area of high crime or racial harassment. And now that was a case on suitability, and if the court will just bear with me for one moment and go to Sharla, tab 16, my lord, page 1696, you will find another decision of the Court of Appeal where the question of medical advisors was for consideration. And the point here that was clear was that when one needs to, one goes to, if I can put it this way, the appropriate medical advisor, not necessarily a general practitioner. And so one has at 207, paragraph 19, it's entirely right, page 207, that local authority officers themselves without any medical expertise should not be expected to make their own critical evaluation of applicants' medical evidence and should have access to specialist advice about it. So in other words, when one's making one's inquiries, that's the course of action that one would follow in an appropriate case. The Shona case is followed in the bundle behind tab 17 by the Pieretti case, which I will have to spend a little longer on than those previous two cases. And this case had to consider, amongst other things, the position under the Disability Discrimination Act. And if you would look, please, at page 212 of the bundle of authorities, the judgment was given by Lord Justice Wilson, and the question was posed whether, paragraph 1, 212, whether the duty currently set out in the Disability Discrimination Act to be replaced in stronger and wider terms by section 149 of the Equality Act applied to the discharge of duties and to the exercise of powers by local housing authorities under Part 7 of the Housing Act 1996. And the answer which came conclusively back was that they did. And if you look at page 220, there was a contention at letter E. The contention was that the duty to have due regard didn't apply to the council's determination whether the homelessness of the applicant and his wife was intentional. And then if one looks over the page at 221, you will see, and I believe it to be sidelined, that paragraph 26, the learned Lord Justice made plain that the duty informed such matters, there being, letter B, no scope for depriving the word functions of much of its normal meaning. Public bodies must factor their duty into the planning of their services, and it may well be that the section doesn't create new individual rights. The part of it with which we're concerned is designed to secure the brighter illumination of a person's disability, so that to the extent it bears upon his rights under other laws, it attracts a full appraisal. And then the point was made about, is the Part 7 dealing with the matter so comprehensively, no room for the introduction of the scheme for making provision for further protection for the disabled, such as exemplified by 49A1. And the answer came back, no. For disability, paragraph 28, to play its rightful part, there must be, so Parliament clearly considered, a culture of greater awareness of the existence and legal consequences of disability, including of the fact that a disabled person may not be adept at proclaiming his disability. Then the 6 specified aspects of duty complement the duties under Part 7 of the housing legislation. And then a submission was made about local authority not carrying out functions within the meaning of 49A1 until it reaches the stage of discharging. I foreshadowed that, and that point was recognised as wrong. And then if you go over the page, you will see at paragraph 31 that the learned Lord Justice had no hesitation in concluding that the duty applied to local authorities in carrying out all their functions under Part 7. And then the substantial effect of my conclusion is in relation to the aspect specified D, that in making a determination where a disability could be of relevance, a local authority shall have due regard to the need to take steps to take account of disabled persons' disabilities. And then he refers to, and I don't read on here, he refers to the case of Cramp and makes a few observations about that. And if you look over the page, though, at 223, paragraph 35, in my view, the reviewing officer was in breach of her duty if she failed to take due steps to take account of a disability. In the context of her duty of review, I would refine the question as follows. Did she fail to make further inquiry in relation to some such feature of the evidence presented to her as raised a real possibility that the applicant was disabled in a sense relevant to whether he acted deliberately within the meaning of 191? A slightly different aspect under inquiry in that circumstance, but that was the position to be followed. And it's clear that this is not a matter whereby the duty of inquiry is, so to speak, referable to anything which the applicant may come to put forward and nothing else, because it's a matter of the local authority or the reviewing officer having to be satisfied. And if you go on in this bundle of authorities to the case of Hotak in the Supreme Court at flag 21. We are within another homeless person's case, this time touching upon the question of priority need, and you will see at the head note that page 266, item 2, a number of members of the court were agreed that where the issue was whether an applicant was or would be vulnerable under the relevant section, a housing authority's equality duty could fairly be described as complementary to its duty under the 1996 Act. At each stage of the decision-making exercise as to whether an applicant with an actual or possible disability or other relevant protected characteristic fell within 189(1)(c had to be made with the equality duty well in mind and exercised in substance with rigour and with an open mind, and that the equality duty in the context of such a review of a housing officer's decision under section 202 required the reviewing officer to focus sharply on whether under a disability or had a protected characteristic, the extent of such disability, the likely effect of the disability when taken together with any other features on the applicant if and when homeless, and whether the applicant was as a result vulnerable. That while a review made in ignorance that the equality duty was engaged might nevertheless comply with it, there would be cases where an otherwise lawful review would be held unlawful because it didn't comply with that duty. I'm not proposing to show the court the judgments at length at all. The only parts, I think, which have been sidelined are at page 296, paragraph 78, which is reasonably reflected in the head note which I've just read out, and also the other part which was sidelined was 297, but I don't need to trouble the court further with that text. And the only other authority that I want to refer to is at flag 22, the Hague case.
Is that right? I thought it was hack.
I beg your pardon. I've had various versions. Hack.
I was going to say that when it's been referred to me before, I'm going to say people have said hack.
Well, I shall say hack
What's
now.
Mr. Hack?
Well, thank you very much, Mr. Hack. I think my friend probably has an advantage on me over this because he was actually in the case. Anyway, it was a decision once again to the Court of Appeal, and you will see in the holding that 303 that in conducting a review require to focus sharply on the relevant aspects of the duty engaged in the context of the facts of the particular review, that where an applicant had been provided with accommodation because he'd been found to be in priority need by reason of disability and the applicant challenged the suitability, the public sector equality duty required the officer to recognise the applicant was disabled for the purposes of the Act and therefore had a protected characteristic to focus on the impairments to the extent relevant to the suitability of accommodation, to focus on the consequences of those impairments, to focus on the applicant's particular needs in relation to the accommodation from those impairments by comparison with the needs of persons without such impairments and to the extent which the accommodation met
Mr. Straker,
particular needs.
would you also say that it's quite clearly bookmarking the fact that you look at the particular circumstances, and it's not just in comparison with someone who is not disabled, as in the case of Hack, but you would also look to see the particular circumstances of the applicant vis-a-vis anybody else, whether or not other people have got that protected characteristic or not. So, for example, taking disability, someone with a visual disability may well be able to accommodate a third floor flat, providing that there was sufficient rail guards and all the rest of it, but someone who was in a wheelchair with no lift couldn't. So both have a disability, but you need to look at the individual circumstances.
Quite so.
And in that case, I'm sorry to sound like a crack record, why would evidence of generality assist Miss Donaldson?
But it's not, with respect, evidence of generality that one is suggesting ought to have been made, ought to have been inquired of. The inquiries which I'm suggesting were appropriate here in order fairly to undertake the task. Analogous to the circumstance when one needs to ask a doctor about some condition or other, how it bears upon somebody. One is making the inquiries which will give both general and particular information about the area with which they are concerned, so as to enable the review to have before it the sufficiency of material touching upon that question of suitability, which we know embraces all these questions. So the question as to is this simply evidence of generalities that you want, the answer is no, it's not that, because what one wants in these cases is an inquiry which is focused, as the cases say, bearing in mind the particular duties, particular characteristics, so as to secure that one has all the material that one can properly expect to have. And I have to acknowledge, my lady, that one might be asking for something which produces the response by the liaison officer. The PCSO, when he has described it in those terms, is right. That might be the position. One doesn't know because he hasn't been asked. Alternatively, he may come back and say, not merely here are the general position and there's a whole load of underreporting you ought to know about, and you ought to be alive to the fact that many, many other people without these characteristics behave in a bad way towards people with these characteristics. He may be able to come back and saying, well, here or hereabouts, the position is one whereby the improvements that have been made in the general population by education or otherwise haven't actually yet taken particular root. And people
And how would he know that?
Well, he's the specialist liaison officer.
Yes, but this goes back to what my lady was asking of you, which is, if you're saying that the liaison officer would have particular knowledge of the area, as good a knowledge as the PCSO, that's one thing. But he or she, the liaison officer, could only be as good as the information that is provided. And if the information is provided by way of computer data, why couldn't the PCSO take advantage of that?
Well, I would respectfully say there's a difference there, which is revealed by that passage that we looked at earlier on about how important it was for the liaison officer to be integrated, so to speak, with the community, that's to say the LGBT community, so as to be able to garner the kind of information and views and feelings that were prevalent, which, with the greatest respect, however good one's computer may be, aren't reflected in the printout of 25 lines which record that Mr. Jones said such and such on a particular day.
All right.
That would be the difference, my lady, and I would say that that's a big difference between the situation between the PCSO and the others.
So what the liaison officer, just to finish off, would be doing would be saying to Miss Donaldson, you say, now Luke, that there is no reported crime, but from my contact with members of this community, I can tell you that there are matters that are unsavoury, and that they may not be a crime, they may have been a crime that's not been reported, but it's out there. I can tell you that from my personal experience.
Yes.
Yeah, I see what you're saying now.
That's how it goes. And that is really important information. And
I don't need you to go further. I just needed to know what you were saying, and now I understand.
I'm much obliged. I'm much obliged, and I'm sorry if I wasn't clear before. That review of those authorities, and with the legislation, so to speak, having been taken as read, reveals and supports the position in terms of the 3 grounds, because as I've indicated to your ladyship, I recognise the strength of my learned friend's observation about the grounds running one into another, and I've sought to crystallise the matter and putting it in terms of the fairness of the inquiries, because when one looks at the skeleton argument, ground 2, page 162 of the core bundle, where it starts at, fail to apply Floretti correctly or at all, goes back to that case which we looked at, which said you've got to take these matters into account in this exercise, and the same holds true when one looks at ground 3, failure to comply with public sector equality duty, sharp focus on the needs with those on a protected characteristic. And so in context of this case, it runs to the point that I have made or endeavoured to make about the fairness of the inquiry which should be pursued. The point that we focused upon in relation to the inquiry is the police point. There is another point as far as the inquiry is concerned, which is that the reviewing officer proceeded upon the footing that you're registered in Wokingham with a general practice, but you could equally well come to a practice nearby, and I've contacted them to see whether or not they have experience of people in your categorization. And there is a point, and I accept it's not as strong as the police point, that the inquiries ought to have gone further than that, to take account of and to reflect the difficulties and apprehensions that people such as my client feel in accessing national health services and in moving from one to the other. And you'll have seen that the reviewing officer proceeds upon the basis, oh, well, I've telephoned them and they can do this, but doesn't dig deeper into the matter than that.
How would she have done that?
Oh, that would probably have been further inquiries of Mrs. Biden herself.
So there was an interview with Mrs. Biden on the 1st of June.
Yes.
And you're saying that at that stage, if Mrs. Donaldson had said to her, well, you know, I understand that you're very, very reluctant to move GPs, as would anybody be, once they've established a relationship. And Mrs. Biden would say, well, particularly in my case, because I've now got confidence in this GP's practice. But actually, Mrs. Donaldson does go on, in fairness to say, Mr. Straker, Mrs. Biden doesn't have to move GP's practice. She can actually just get on a bus for an extra 2 stops, or however many
Yes.
stops, to go to the same practice, which she's kept throughout her time living in the other address, which I won't refer to by name either, just in case
Yes. Yes. No
you don't
problem.
want that referred to.
Quite. But that is the character of the aspect, because one aspect which is applicable to people such as my client is this apprehension over such movement. But I can't say anything more in relation to that particular point than I've done. And so I'm putting these matters before the court in terms of the inquiries which ought to have been made in order to comply with that obligation fairly to inquire, as I have put it. And that is alongside, but it's not in the forefront of the matters that I'm submitting to the court. Now, I suspect, my lady, that I can probably sit down shortly because I hope that I've covered the sufficiency of the character of the case, because, as I say, this really is a case of some significance as to what should amount to those fair inquiries, and that text which I've adopted as the proposition, I respectfully submit can be the watchword in the light of those more recent cases which indicate these other aspects have to come forward. One matter which I haven't specifically stated, but which is plain, is that inquiries aren't required, or let me start another way, put that another way. There's no ability on the part of a housing authority to say, we didn't inquire about your disability or the consequence of it because you weren't sufficiently forward in telling us about your disability.
I don't think that applies in this case, does it?
I don't
Because
believe
Mrs.
it
Biden's
does.
been very straightforward.
Yes, absolutely, absolutely. But one can't, so to speak, hide behind the proposition this is some sort of adversarial litigation where if you haven't said something, we don't have to deal with it.
I do think, though, Mr. Straker, that there may be a point to be made that the solicitor's letters in this case that were sent on Mrs. Biden's behalf were not exactly covering all the bases, were they? The first one didn't even mention Mrs. Biden's gender reassignment. The second one did, but it wasn't followed up. And Mrs. Donaldson makes clear in her review letter that she had specifically asked for crime and incident numbers relating to any incidents experienced, but they'd not been provided. And then they're provided in the statement. There's one thing to say, you don't have to look at a man and say, well, you don't raise with me the possibility that you're disabled, but I'm very worried about your presentation, yes, as in the case of Mr. Pieretti.
Yes.
And somebody who's saying, well, I've had all of these issues, and then further and better particulars are requested, and they're not made available. I mean, there is a difference.
No, I grant you the point, my lady, if I may, that those letters could have been better. But does that disable the proposition as to on whom the burden of making the inquiries lay? No. Does it disable the proposition that those inquiries had to be sufficient in order to satisfy? No. does it disable the proposition that those inquiries had to be sufficiently fair, or to enable one to be able to say, "Look, I'm sorry, you've reached the end of the road here." It doesn't actually do that, my lady, with respect.
Well, that's where there's a potential difficulty on the fairness. You can't expect people to shadow box. If you're dealing with something fairly, fairness requires cards on the table.
Yes.
That's a watchword of all kinds of civil dispute, however one categorises them. So for a local authority to deal with something fairly, it's what is it that they're dealing with? Well, it's the information provided. But of course, there are other obligations on them, which you've made plain, and Miss Donaldson herself dealt with. I mean, you could say that the first in time document here that dealt fully with the gender reassignment of your client was Miss Donaldson's review. I mean, it's pretty comprehensive in relation to that. I quite understand.
Yeah.
You say not comprehensive enough, and that's the heart of the appeal. But to be fair to the respondent, Miss Donaldson's report does deal with a large number of these matters in a very full and open way.
Well, my lord, I opened by saying and paying some tribute to the professionalism of the author of the letter, author of the review, and I don't resile from that at all. What I've made plain and endeavoured to make plain is that when one pursues the line of seeing who has got to be satisfied, who has got to make the inquiries, those inquiries have got fairly to satisfy, and was there a sufficiency there? My question for the court and my submission that there wasn't, doesn't really get answered in my respectful submission by saying, well, the solicitors haven't provided any figures, when the position was one whereby the officer was making the inquiries and in a position to, as demonstrated by bringing up the community support officer, of making those inquiries of the police force.
Well, we'll park that to one side, but my lord's point is fairness is as fairness does, and if inquiries are thwarted by a lack of information that could have led to further inquiries, it's very difficult, isn't it, to, as I say, suggest that Miss Donaldson, with one arm tied behind her back, was not acting to make sufficient inquiries. There was available, as is clear from Mrs. Biden's statement, some details that she could have been provided with.
Yes, that statement, of course, was done for the purpose, if that's the one your ladyship has in mind, for the purpose of the appeal to the judge.
Yes, I am.
Yeah.
But in the review letter, page 16, paragraph 3b, I have asked you for crime and incident numbers relating to any incidents you have experienced. You have not provided any incident or crime numbers. And then C, rather than indicate the adverse attention of others, Mrs. Biden made reference to 2 occasions when her name had been published on an online website, which referred to Mrs. Biden by name and in general address. And then, only then, at E, I spoke with you on the 1st of June. You said you'd received threats from your wife's family as they do not approve of your relationship, and this is why you cannot live with your wife in Wokingham. You'd not reported any issues to the police in relation to any threats from your wife's family. Previously, you told us that you felt you were at risk from gangs in the Wokingham area. You mentioned having received a letter. But it's clear here, isn't it, that Mrs. Biden was probing with Mrs. Biden. Miss Donaldson was probing with Mrs. Biden. Well, tell me more. Give me the kind of information that a liaison officer would be able to say to Mrs. Donaldson, well, you know, being immersed in the culture, I can tell you that these are the things that happen.
Yes, it's that second step which I would take issue with, if I may, my lady. As far as the first aspect is concerned, your ladyship is perfectly right to say it's clear that the reviewing officer was probing with Mrs. Biden these matters and what do you know about these matters and what can you tell me about these matters. But I would part company with you, my lady, when the proposition is that she would then have been able to say that which the liaison officer could have drawn to the attention of the reviewing officer. I would part company with you there for the reason that Mrs. Biden is one such person within a particular community, and it's that particular community and the impact of the general public upon it which the liaison officer has or ought to have at his or her fingertips. Okay. And it's that material which I say was lacking. And your approach, my lady, is one which very sensibly, if I may say so, looks at this section 3, your safety, and goes through, well, this is what was being pursued of Mrs. Biden and recording those answers. And it's the professionalism of the letter makes plain that the author did all that, got a certain amount of information, but still thought, I need to make further inquiries. And did make further inquiries because page 140 of the core bundle 17 of the document itself, letter F, I've contacted the police. And so,
you say it was the wrong person.
Absolutely.
Yeah.
And so what happened was the reviewing officer obviously thought, I've got to talk to Mrs. Biden about this. I'm going to get some information about Mrs. Biden about this. I would say sotto voce there, but be careful because Mrs. Biden's not going to be in the best position or any position to give you the full picture. And then she says, I must get in touch with the police. I do, and that's where I say the trip up occurred. And my lady, unless I'm reminded of anything else, that's what I would wish to submit to the court, or unless the court wishes to ask anything further.
Unless we haven't been shy, Mr. Straker,
No,
as
no,
you
no,
know,
no.
but we've done it so that we can understand the cases we've gone through, rather than come at the end with a myriad of questions. I'm sure you understand that.
And I trust that the referential approach to the legislation was sufficient for the court's purposes.
I think so, very much so. My lady, any further questions? My lord.
No, for me, I've been very shy.
My lord says that he's always shy, but I'm not sure about that.
So am I, my lady.
But
I'm
thank you
much
very
obliged.
much, Mr. Straker. And Miss Heath, you don't follow, given that you've been asked for your opinion. Thank you. So, Mr. Rutledge.
My lady, first of all, I'm grateful to my lady for the indication, though in my respectful submission it's obvious from the exchanges that all three members of the court have been ready in this. And I shall bear that in mind in my submissions, and I hope that I can match my friend's economy. The case, as we understood it on the skeleton argument for the appellant, was threefold as follows. Firstly, in relation to the PSED, and it's all about the PSED, there's a heightened duty on the reviewer requiring a sharper focus where the applicant declares the protected characteristic of gender reassignment either as a standalone characteristic or in combination with disability, than where an applicant has it put forward the characteristic of disability alone. So our understanding of the case represented in the three grounds is there's a heightened duty. Of course, my friend didn't accept the lady's point about whether his client was seeking preferential treatment. And so I think the focus of that point has become less sharp in the exchanges, and it's
Yes.
really become an inquiries point. But I put it there, I need to deal with it,
Right.
because permission was granted on that ground.
Well, Mr. Rutledge, I think, if I may suggest, and subject to either of my lady or my lord not being shy and shouting me down, that there has been a sharp focus brought upon the actual appeal that's being made. And it would certainly help me to have you meet head on the issue, which is Mr. Straker's point. The inquiries that were made were not sufficient.
Yep.
And if they weren't sufficient, it was because Miss Donaldson didn't go to the right person. And if she didn't go to the right person, then Mrs. Biden cannot be satisfied that there has been fair play, and effectively this becomes a reasonableness challenge.
Milady, yes, I'm grateful. I intend to do that. I'm just simply identifying the issues in broad terms, but I have well in mind Milady's point, and I will focus my submissions accordingly.
I'd be very grateful if you would, and I'm sure that my lady, my lord would too.
Yes.
I mean, we've taken it that Mr. Straker's concession, that your skeleton argument very clearly says these three grounds are really one and the same thing.
Yes.
I think is reasonably and well made, and therefore
Yes, we can deal with them
Yes.
in a rolled up way.
Yes,
Milady, I
absolutely.
intended to do that. Secondly, and it's linked to that, the contention is that the logic of Pieretti is that the reviewer must make inquiries commensurate with the duty, even if the appellant, the applicant as she then was, has not suggested them. And thirdly, the core submission is that Miss Donaldson fell into error by not better informing herself of the problems that trans women typically encounter in the community, and specifically not seeking specialist advice, for example, from the dedicated LGBT liaison officer. Secondly, by not considering material that was in the public domain, for example, the Stonewall material that was put before the judge. And thirdly, assuming without more that the appellant could change her GP. As I understand it, those are the three specific areas in which it said that there was a deficiency, a lack of proper inquiries. Milady, if I could just set out very broadly Waverley's position on those. Firstly, we submit that whereas each case will turn on its own facts, there's no general rule that gender reassignment enjoys any enhanced status under the Equality Act, calling for a sharper focus than any other protected characteristic. There's no general rule. Secondly, in relation to indirect discrimination, there's no principle, in fact generally under the Act we say, there's no principle of dual characteristics or sectionality. My friend hasn't promoted this in his oral submissions, but it's a major feature of the skeleton. And we say respectfully that it's a matter for Parliament to introduce any concept of sectionality or dual characteristics outside the specific context of Section 14, which I'll take the court briefly. Thirdly, we say that the combination of disability and gender reassignment that's at play here is no different in principle to the combination of disability in any other characteristic, protected or otherwise, and properly understood. That situation is already provided for in the authorities, and in particular HOTAC and HAC. Fourthly, we say that Pieretti was addressing a different problem and should be distinguished. And finally, we say that Miss Donaldson conducted adequate inquiries compliant with the PSCD as interpreted in HOTAC and HAC, leading to a lawful decision. We say respectfully the judge was right in those circumstances to dismiss the appeal. Lady well knows that the convention in all these cases is to focus on the review decision rather than the county court judge, no disrespect intended. So, lady, with that opening, the submission, and I'll make it as briefly as I can, but it's important to my client that I deal with these matters, is in 4 parts. Firstly, what is the standard of inquiries in a suitability case where the PSCD is engaged? Secondly, how does the Equality Act treat gender reassignment and dual protected characteristics? Thirdly, I was going to say something about the factual background, but I'm not sure I need to do so given the level of knowledge this court has. Anything I say would be way of emphasis. And finally, Waverley's submissions on the lawfulness, the sufficiency of Miss Donaldson's inquiries. So if I could just begin with the standard of inquiries, and I'll take this as quickly as I can. The court has been referred already to the Bayani case, which is a tab 11. And if the court would turn, please, to page 105 of the report, the judgment of Lord Justice Neal, we there see the terms of section 62.2 of the Housing Act 1985. And that's a duty to make such inquiries as are necessary to satisfy themselves. So this is the Court of Appeal looking at the appropriate test for inquiries to meet that statutory provision. And the court has been shown the page 106, the 3 or 4 indented paragraphs which set out the basis of the decision. And it's essentially a Wednesbury test. And in particular, reliance is placed on Lord Brightman's speech, well-known dictum in the Pulhofer case, about the broad spectrum ranging from the obvious to the debatable. So essentially, the Bayani test is one that shows considerable deference to the local authority. It's a Wednesbury only. The court will not interfere unless the inquiry is one that no reasonable authority would fail to apply. That's the the Bayani test. Now, section 62 is replicated in section 184 of the current Act, but neither Act deals expressly with the standard of inquiries necessary in a suitability case. And our submission is there. Of course, local authorities have to make inquiries. What's the legal nature of those inquiries? And the legal nature is, we say, it's a Tameside duty. A public law Tameside duty. We footnote this at 11 of our skeleton. And a Tameside duty, of course, is a duty to inform oneself of the relevant facts to enable to make a decision. And I needn't turn it up, but we've put in the bundle at tab 20 an excerpt, because it's a long case, of the Plantagenet Alliance case, where judgment of Mr. Justice Haddon Cave, as he was, very respectfully, very helpful judgment, sets out the legal basis for the Tameside. And all I need to say is his lordship refers to Bayani. So Bayani is that the
paragraph
test.
100?
I'm so sorry, 100.
Paragraph 100.
Paragraph 100. I can take the law to
No.
320, 100.
That's the bit I had flagged up. 100.
Thank you. Yeah.
So you're just referring to that as being the summary,
yes,
and noting the reference to Bayani.
Yes, yes, my lord. Yes. And so whether it's the statutory inquiry we get under section 62 of the 85 Act, or now 184, or it's the Tameside duty, it all comes down to the same thing. So that's the position under the 85 Act. We then come to the 96 Act, and as the court knows, the 96 Act introduced, amongst other things, a statutory review and a statutory appeal. Hitherto, local authorities had ad hoc, non-statutory appeals, and then it went directly to a High Court judge. And the effect of those changes was considered by Lord Justice Brooke in Cramp, which is at T15. Again, the court has been taken to it. I'll be as brief as I can. And if we go to 176, paragraph 1, I'm so sorry, 177, paragraph 2 of Lord Justice Brooke's judgment, sorry, paragraph 3, in both these cases, the critical question turned on the sufficiency of the inquiries made by the local housing authority, both at the initial decision stage and the review stage. That's the issue. If you go to page 180, paragraph 13, and there Lord Justice Brooke makes the point I've just put forward, that the 1996 Act introduced the statutory review and appeal. And then in the important passage is paragraph 14, page 181. As I've shown, the review procedure gives the applicant and or person on his behalf making opportunity to make representations about the elements of the review to satisfy them. And there's reference to Sardonia and Ealing. Review is the appropriate word for that, submitting for examination and revision an inquisitorial administrative decision. And then this, given the full-scale nature of the review, a court whose powers are limited to considering points of law should now be even more hesitant than the High Court was encouraged at the time of ex parte biani if the appellant's grounds of appeal relate to matters which the reviewing officer was never invited to consider and which was not an obvious matter he should have considered. So the 2 points there, matters that the reviewer was invited to consider and under the review regulations obliged to consider, or otherwise matters which are obvious. And that was the setting of this court's decision in Chiaretti, which is tab 17. And it's important to bear in mind, in my respectful submission, what Lord Justice Brooke said there. Chiaretti, my lady, was a test case on the application of the PSED to individual decision making. Nowadays, we may be surprised about that, but this goes back a few years. It wasn't clear to local authorities, it wasn't clear to county court judges whether the PSED applied just at the macro strategic level or also at the micro decision level. So it was a test case on that. That's what the case is all about. All I need to say about Chiaretti is this. No consideration was given by the reviewer to the PSED. On the face of it, it didn't arise because the decision in Chiaretti was about intentional homelessness. There was material on the file that both Mr. and Mrs. Chiaretti had medical conditions. No inquiries were made about that. But Lord Justice Wilson refers to the Code of Guidance, which says that an element of intentional homelessness may be a mental element. And therefore, this was a case where an awareness of the PSED might have made a difference. If the decision maker had approached the decision with the PSED in mind, then she might have directed herself that it was relevant. That's all Chiaretti holds. That's the ratio of Chiaretti in my respectful submission. And it's a case where it's been cited subsequently. More often than not, it's been distinguished for that reason. Very briefly, we can compare Chiaretti with the next authority in the bundle, which is MacDonald. and this is a decision of the Supreme Court. It's not a housing case, it's community care, but it's very closely aligned. And this is a case where the Supreme Court was concerned with the legality of a community care assessment under which a nighttime carer for a client who had a need to urinate 2 or 3 times a night but had physical disability in getting to the bathroom, an assessment to withdraw that carer and replace it with incontinence products. That was the background, and there was an argument, a ground of appeal, was that in arriving at that conclusion, the local authority had failed to consider the terms of Section 49 capital A of the Disability Discrimination Act 1995, which is the predecessor of the current PSED. And as to that, and speaking for the majority, at page 230, Lord Brown said, "This argument too is, in my opinion, hopeless. Whereas here the person concerned is ex-hypothesized disabled, and the public authority is discharging its functions under statutes which expressly direct their attention to the needs of disabled persons, it may be entirely superfluous to make express reference to Section 49A, and absurd to infer from the omission to do so a failure on the authority's part to have regard to the general duty." So we've got Peretti on one hand, where the protected characteristic disability and the decision at hand, intentional homelessness, are not aligned. There's no obvious overlap. And we've got MacDonald at the other end, where there's almost complete overlap. They're already looking at the question of disability. And that alignment point is one that comes out specifically in the 2 key cases here for this court, Hotak and Hack. We can go to Hotak, which is 21. The lady, the court will know this anyway, it was only Mr. Carnu who pursued the PSED point in this case. Most of the case was about the meaning of vulnerability. But if I could just invite the court to note some particular passages. At 275 of the bundle, we get the argument from Mr. Underwood, Queen's Counsel, and Miss Rowlands for Southwark in that case, essentially saying that the PSED adds nothing, and over the page relying on MacDonald. Interestingly, the government, page 267, G to H, take the same line. Conscientious compliance with its statutory duty. And the PSED in those circumstances adds nothing to the duty. And then 285, principal issues raised on these appeals. 46, can I just mention 46, because Lord Justice Lewison, in a case in which Lord Justice Coulson appeared, was a member of the court. McMahon picked up on 46, and I'll come back to that, about avoiding an arid argument, not putting the reviewer into a straitjacket, matters of that nature. But the gist of the PSED point is dealt with in the judgment of Lord Newberger, President of the Supreme Court, at 78 and 79, that's page 296. 78 describes the duty as complementary. And then it's important for present purposes in our respectful submission to read from D to E of that. It is therefore appropriate to emphasise that the equality duty in the context of the exercise such as Section 202 review does require the reviewing officer to focus very sharply on whether the applicant is under a disability or has another relevant protected characteristic, 2, the extent of such disability, 3, the likely effect of the disability, and this is the important point, when taken together with any other features on the applicant if and when homeless. Relying on that passage, we submit that where a local authority is seized of an application, where it falls to the local authority, will keep it within the confines of suitability to decide whether accommodation is suitable, and the circumstances disclose the protected characteristic. They have to they have to have an awareness of that protected characteristic and its potential impact on the decision in hand. But we say that requires a composite or holistic approach to decision making, where that factor, that protected characteristic, is factored in to all the other circumstances relating to that applicant. And all those other circumstances may include another protected characteristic. So as we say in our skeleton argument, if, for example, a disabled person is offered accommodation and it falls to a reviewer to consider the suitability of that accommodation, of course the reviewer must look at that person's disability and the aspects of it and how it impacts and so forth. But that person might have other characteristics. They may be very elderly or frail, they may be a care leaver, they may be a former prisoner, they may be transgender, they may have all these things. Some of them are protected characteristics, others are not. And what we get out of that is guidance, clear guidance, we say, as to how a reviewer should deal with this case. It's not a question of dual characteristics under the Equality Act. As we see, Parliament has declined to go there. It's simply a way of taking a composite approach. So the proper approach in this type of case, we say, is this. Mrs. Biden declares that she has a disability. To look at that disability, to understand the nature of that disability and how it impacts on the accommodation, how she would be peculiarly disadvantaged vis-a-vis her disability. But then also, as a part of the composite assessment, to look at all the other characteristics that Mrs. Biden had, one of which happens to be another protected characteristic. And in our respectful submission, a fair stand-back view of Miss Donaldson's decision, that's the Lord Justice Briggs approach, the fair stand-back appraisal of it, and she's done precisely that. She's looked at each and every element. I'll come on to it. So we pin our case on 78 of HOTAC. I mean, obviously HOTAC comes with a health warning because it's a case on vulnerability, not on suitability. But we say respectfully that that dictum there is a wider application. Where we find guidance specifically on the context of the interplay between the PSED and suitability is in the HAC case, which is at tab 22. And without labouring the point, Lord Justice Briggs in that case did, I can find the references, did sort of accept this alignment point by comparing the Ferretti type of case with the McDonald case. And
isn't the violent agreement between everybody, Mr. Rutledge, that if you've got somebody who presents as homeless,
yeah,
as in this case, so we've got past that hurdle, and you're looking at suitability, it's not appropriate to put things in silos and say this accommodation would be appropriate for you as a disabled person because your disability is A, B and C.
yeah.
And I look at another silo and I say, Well, in the other silo, there's the protected characteristic. It may be age, it may be race, it may be gender reassignment. But I've got to look at the context as a whole.
Yes.
And if you do that, this is the PSED and the Housing Act running in tandem in terms of suitability. It's Pioretti running in tandem with the other cases, because it's saying, you know, you look to see what's about and you make an overall assessment of the case. And it's certainly in line with HOTAC, which is saying, you know, you look at all of the factors of the individual's case.
Yes.
So the fact that somebody is disabled doesn't necessarily mean that that predicts an outcome.
No.
It's the facts of the disability in the context of the wider decision. So I think there's wide and universal violent agreement on that point, and I didn't understand Mr. Straker to be arguing otherwise. His point, of course, is in this case that didn't happen because of the inadequacy of those inquiries. So I'm sorry to rush you on like that, but
not at all, my lady.
You made the point very well in your skeleton argument. Mr. Straker doesn't take a perception to that, quite rightly.
Well,
but
lady,
I think we can move on to the
lady,
adequacy.
Let me move on. I can take a hint, my lady, and just...
We all can.
Can I, just before I invite the court to consider Waverley's submissions on those core issues, can I just ask a question, perhaps rhetorically, as a practical problem in this case? And it's, what else, in terms of, the question was, the duty was to secure that suitable accommodation becomes available. That was the duty. It's not a duty to ensure that Mrs. Biden is safe in the community for all matters. That may well be an element of it, but the core duty was to be secure suitable accommodation. The only issue was locality. I mean, I acknowledge there was a concern about this block was typically used for single mothers. I think that was, but that, in my respectful submission, is also an element of aspects of locality. So everything else would be taken as suitable space and arrangement, affordability, security of tent, all those things, all about that. Waverley, as a matter of law, had to first and foremost secure accommodation within their own borough, section 2081. So far as reasonably practicable, a local authority to secure accommodation in its own area. So it had to be in the borough. The court will have seen from the review decision that Farnham was chosen because it was the nearest town to the border with Wokingham. So geographically, it went into the most, the best part of the borough. It's not being suggested in this case that we should have made a local connection referral to Wokingham, and they probably couldn't have done that because there's a bar under section 199 to referring someone to an area where they're at risk of violence. So they couldn't make a placement in Wokingham. They had to accommodate in the borough, even if they were lawfully entitled to accommodate outside there, somewhere else. The problems would be compounded. Mrs. Biden was complaining about the remoteness of the area. To stick a pin in a map and say we'll refer you there, not only would that have been unlawful under the Housing Act, but it would have been unfair on Mrs. Biden to do that. So the options were not unlimited here. And I just make that by way of general observation. But what is said specifically in this case, where it falls down, and I think the friend is really putting this on the sort of Bayani basis, where no reasonable reviewer would have failed to make further inquiries is in three respects, and let me address those here now. Firstly, it said that it wasn't sufficient to go to PCSO Francis for advice about safety in the area? And we say two things about that. Firstly, we say, well, PCSO Francis was the local officer with local knowledge. And the question for Miss Donaldson was, in terms of location, would this accommodation, situated as it was less than a mile from her existing accommodation, would this present any threat to her? They go to the local person with local knowledge who has available to him reports and crime figures, and he gives that and he gives an appraisal. And the court will have seen from the review that PCSO Francis looked at both properties and gave a comparative view. So the point number one is they've gone to the most direct person. I mean, one could see, turning it on its head, if they'd just gone to Surrey, the liaison officer who said, well, I don't know that area, I can tell you generally in the United Kingdom, but I don't know that area, and didn't go to the PCSO, there might be an argument that they didn't go to the best source. So my first point is they've gone to the grassroots source by the PCSO. The second point is, if we look at that police guidance that the friend referred the court to, which is at Supplementary Bundle 131, this document, I think, was put in at the county court stage. It's the College of Policing Hate Crime Operational Guidance 2014, that's page 79, and the court was invited to look at page 131 under the subheading Liaison Officers, and it describes the purpose of the liaison officer. Can we just focus, please, on the last sentence? This liaison role helps build trust and confidence, increases accessibility to the police through an identified contact point, and provides a specialist advice point for other officers. So presumably, PCSO Francis could have gone, had he considered it necessary to do so, to the liaison officer in Surrey and said, well, look, I've got this inquiry, can you just fill me in with some background information? And then it comes down to a question, is it reasonable for Miss Donaldson, the reviewer, to rely on the information that PCSO Francis gives her, or does she have to check that he has considered the possibility that he might need to take specialist advice from the liaison officer? Now, if we read that into the inquiry, that will have serious implications for all reviews, that the reviewer officer cannot rely at face value on what they're told by PCSO Francis. PCSO, as my lord will know, is a statutory role. It's a well-defined statutory role. So our second point on that is that in any event, it was entirely reasonable for the reviewer, Donaldson, to rely on what PCSO Francis was telling her, and to rely further on the point that if PCSO Francis felt that he needed more specialist information before responding to the inquiry, then he would take it. In addition to that, we do very respectfully ask, as my lady asked, how would it inform, how would generic information, obviously we all know there's a problem, but how would it impact on the suitability of this accommodation? How would the reviewer usefully and sensibly process that information and feed it into the limited decisions she was taking? So we say respectfully that if this is going to be a Bayani approach whether one is looking at it with a sharper PSED focus or not, then on any test, it was a matter of judgment for Miss Donaldson. She ran with it. She wasn't given very much information at the review stage. The May letter was the only one that really gave any information. It didn't give much. There was the interview on the 1st of June. But as my Lord has observed, the real document, the first document to really grapple with it is the review itself. Doing her best, having made proactive inquiries and been given information, she then puts that in to the mix and decides that the accommodation is suitable. So we say on either test, on the traditional Bayani test or on the sharp focus test, and this court knows full well that PSCD is about process, not about results. It passes comfortably for a lawful inquiry. That's what we say about that. Secondly, I don't think the friend has really pushed this to any great extent in his oral submissions. There's a failure to look at the information in the public domain, this Stonewall, and we say about that, respectfully, that that's very helpful information, but it's of a general nature necessarily, and it's unlikely to bear on this limited question of whether this accommodation is suitable for the applicant. The third point in which it said that the inquiries fell below the Bayani standard was in relation to changing the GP, but as my lady has observed, that wasn't what the review decision said, and the judge picked up on this at paragraph 48 of her judgment. What the review decision says is that we consider that it is reasonable for you to carry on accessing your existing facilities, your support centre. We've looked at how far it is. We've looked at the bus routes. We've looked at your difficulty using the buses, things like that. We can say, but if you choose to move, we've made the inquiries. So it's simply, with great respect, a mischaracterisation. Lady, whether it would assist the court or not, Lord Justice Briggs in Hack identified 6 questions applicable to that case.
Paragraph 43.
Yeah.
Is that the one that you wanted?
I'm sorry.
Paragraph 43, is that the one?
43, yeah.
Yeah.
It's right ahead of me. And the lady will also have seen that Lord Justice Macur in that case.
Yes, Macur.
Yes, 63, whilst not wanting that to. Yeah. So can I just very briefly run through that as a cross-check, to demonstrate that Ms. Donaldson's decision was compliant with, and because the court is familiar with the review decision, and for the sake of time, if I may, I'll just cross-reference. The first question is, or first thing the local authority has to look at is a recognition that the applicant has a protected characteristic. Disability is recognised in sections A1, A2 and A4 of the review, and gender reassignment is recognised at A3. Secondly, there has to be a focus upon those specific aspects of the applicant's protected characteristics to the extent relevant to the suitability of the accommodation. Again, in relation to disability, there's A1, A2 and A4, and gender reassignment is A3. Thirdly, there has to be a focus upon the disadvantages to the applicant if he accepted the offer compared with others without the applicant's protected characteristics. In relation to disability, we say D1 to 4, and gender reassignment D5 to 6. Fourthly, there has to be a focus upon the applicant's particular needs in relation to accommodation arising from her protected characteristics when compared with the needs of persons without protected characteristics, and the extent to which the accommodation secured met those particular needs. Disability, we say E3 little c onwards, and gender reassignment, we say F5D to N, F5D to N. Fifthly, and here I will just pick up 2 references in the review. Fifthly, a recognition that the applicant's particular needs arising from her protected characteristics might require her to be treated more favourably. This is 1496. If we look at the review, we find that if we go to 142, the bundle, this is section FK, F little paragraph K. The decision maker considered the impact of your protected characteristics and your circumstances with an open mind and concluded that private landlords may discriminate against a trans woman, making it harder for you to find accommodation than someone without the protected characteristics. The decision maker concluded that because of the impact of your protected characteristic and other circumstances, it was appropriate to refer you to accommodation managed by a social landlord, which had ethical and social values. This offers you a greater degree of protection than you have had in the private related sector, as some private landlords do not operate the most professional standard. That's an example of positive action. Otherwise, in normal circumstances, you might have been given a PRSO in the private rented sector, but here we're placing you with a social landlord with social values and standards. And then finally, a review, this is go back to Lord Justice Briggs, a review of the suitability of the accommodation secured, which takes account of the previous factors. We say the entirety of section F of the decision does exactly that. And can I just, for completeness, refer the court specifically to page 141, FH. And this is where the reviewer is grappling with it and putting disability and gender reassignment together in this holistic way that we say para 78 of HOTAC requires. If victimised by someone because of you're a trans woman, it may take you longer to remove yourself from that situation. This is because and so and so. So the reviewer is on the spot there, looking at this interplay between the two. So we say respectfully that whether one looks at this through applying the Bayani test or the Bayani plus test, as Lord Justice Brooke might have put it, with the complementary discipline that the PSED, and if one, or alternatively, or additionally, if one looks at it with the Lord Justice Briggs factors in mind, we say that this decision lay comfortably within the range of decisions lawfully and rationally available to the reviewer. We say in those circumstances the judge was entitled, we say obliged, we would say, to dismiss the appeal. Might I just...
yes, of course.
No, I don't think so. Yeah. Okay, well, unless I can assist the court in anything else, in particular in relation to the Equality Act issues on which I have a specialist to my right.
No, thank you very much, Mr. Rutledge. Mr. Peck, do you follow? Thank you. So, Mr. Straker.
My lady, I wouldn't wish to be long because my respectful submission, any difference on the law between us is more apparent than real.
Absolutely.
And we are heading in the same direction. I just wish to highlight in the light of what's been said, or crystallise in the light of what's been said, what was ultimately required was consequential upon section 189B7C to be satisfied that there's been an offer of suitable accommodation. I emphasise that the way in which that is done, I think my learned friend used this word, composite and individual. I don't seek in any shape or form to go behind Bayani, although I draw to the attention of the court, just for noting purposes, at volume authorities, page 220, Pyretti, a point is made about Bayani, where the learned Lord Justice puts a contingency about Lord Justice Brooke's dictum in the Cramp case.
Yes, thank you. I was actually looking for that reference
Yes.
when Mr. Rutledge was
Yeah, well, that's where it is,
referring to that.
paragraph
It's
23.
222, is it?
220, the page
220.
number, paragraph 23, it's page 575, top right-hand corner of Peretti.
Thank you, Mr. Straker.
But I was simply doing that, so to speak, for reference points, because I'm not seeking to go behind
No,
Bayani.
understood.
I simply say that Bayani says sufficient fairly to form a view, sufficient inquiry fairly to form a view, and that fairness will be dictated by the composite and individual approach, which will include all these matters that we have been pressed with in this particular case. And my lady, that effectively is all that I would wish to say in reply. As I say, barely a reply, because differences as to the law more apparent than real, and I haven't been able to identify those apparent differences.
No, and when you've brought us into the, as I said, Mr. Straker, the sharp focus of where the appeal is.
Yes.
And that's been very helpful.
I'm much obliged. Well, unless there's any other matter I'm reminded of, or any other matter that the court would wish to...
Yes, it's the question of the address that we left to one side.
Yes, well, I haven't, as you have been able to take instructions.
Well,
talking in
why
public.
why don't we take this step, Mr. Straker? Obviously, there are issues to discuss. We had the opportunity to discuss that discrete point earlier on, and we see no magic in giving the actual address. We can give the area in which it was, and I don't think anybody could object to that, because it's not the address itself that matters, it's location in general.
Yes.
And in terms of the accommodation offered. So we do not want to cause any problems, regardless of what we say otherwise as to the merits of the appeal, for anybody. And if it's not necessary, we won't go there.
I'm much obliged, and that will be sufficient.
That's got to be right, hasn't it, Mr. Rutledge?
Yes.
It's important to my case that the accommodation offered is within a certain distance of the accommodation,
Yes.
but the court can deal with that in a way without disclosing.
The actual address, yes. And there's no magic in number 2, is there? Or in the Hopfields Drive. It's the Farnham
magic
area.
at all in
No.
that. No,
That's
no,
the point that
but
Mr. Straker was making. I
Geographical
think.
placement in the
Yes.
area, proximity to all those things,
Yeah.
the court can deal with in a sensitive way without. So you're not receiving an application from me to publish addresses.
Good, good. And we will refer to Mrs. Biden throughout, if she's happy for that to be so. We don't see any basis to say that her name shouldn't go forward. And in fact, speaking for myself, I can only speak for myself, I think it's far more polite to refer to somebody by name than call them the appellant all the way through, quite frankly. And I will also refer to Miss Donaldson in the same way, rather than the reviewing officer.
Well, I'm much obliged, and sometimes using these terms, reviewing officer and other similar labels, simply disguises the fact that one might not have take sufficient time to learn the names of everybody in the case, and so
Well,
one can blame oneself.
They can be learnt but forgotten
Yes,
with age,
yes,
Mr.
exactly.
Straker.
Well, that happens too.
Yeah, I've been there, yes. So thank you very much.
Much obliged.
So we will obviously reserve our decision. We will send out a draft in the usual way. You have the opportunity then to correct our English but not our reasoning, as you know. Once the returns have been made and considered, we will obviously hand down judgment remotely, which is now the usual way. It would help once you've acclimatised yourselves with the judgment to put your heads together for any order that follows.
Yes.
We hope that the judgments will be sufficient in order to tell you what that will be. And any further applications at first instance in writing, please. May I thank you both with your respective juniors, Miss Heath and Mr. Peck. We were able to do considerable pre-reading. We've read perhaps a little too much given the focus now brought to the appeal, but that was no bad thing. It meant that we could look at it in context. We've been very much helped by all oral submissions. I do thank Mrs. Biden for her presence, and I'm not sure if Miss Donaldson's here or not. I suspect she is, and I thank Miss Donaldson also. But thank you all very much. It's an interesting case.
Much obliged, my lady.
Okay.
Hello.
Tim,
Hello.
90 seconds.
Right, yes, and the abuse that one can now tender to you only